In this case, my lord,
Hmm.
the petitioner, my lord, they are the defendant in the suit, my lord,
Hmm.
and suit was dismissed, my lord. Plaintiff suit was dismissed,
Hmm.
and thereafter, my lord, an appeal has been preferred, my lord.
Hmm.
And during the pendency of the appeal, my lord, a petition has been filed. Lordship may kindly come to page 156, my lord. So judgment was delivered in the year 2012, my lord. And thereafter, now, my lord, in 2024, my lord, they file a petition allowing the appellant, my lord, to submit some treasury credit certificate to be deposited, my lord. So basically, it was only for submission that a petition has been filed by the advocate, my lord, by the counsel of the appellant, my lord. Now, my lord, trial court, my lord, considering this petition to be a petition under Order 41, Rule 27, my lord. That is, my lord, during the evidence stage, appellate stage, my lord, if somebody want to file evidence, my lord, then, my lord, in exceptional circumstances, it is allowed. So now this order has been treated, my lord, and, my lord, the court has, beyond the parameter, my lord, what has been guided by Order 41, Rule 27, court has allowed the petition without hearing the matter, my lord. So, my lord, and my lord may kindly come to, my lord, the impugn order, my lord.
You see, there's an order here.
Yes.
It appears that the impugn order.
Yes, my lord. I have already filed an additional affidavit to that effect, my lord. Actually, my lord, the last page of the order, my lord, there's an internal page 13 of the impugn order was missed, my lord, in the while filing, my lord. So I brought this on record, my lord, on the last occasions.
So appellate court allowed you to
allowed the appellant, my lord,
to adduce evidence.
to adduce evidence of a certificate of 2018, my lord. Judgment delivered in 2012, my lord. And now it has been remanded back to the trial court to take evidence and thereafter send this matter. Now, my lord, the crucial point, my lord, to be adjudicated, my lord, at what stage, my lord, that petition under Order 41, Rule 27 has to be considered, my lord. It is a settled position of law, my lord. I will just take your lordship to one of the judgment, and it's very clear, my lord. Short issue, my lord. Lordship may kindly.
You want to stay?
Yes, my lord. Because, my lord, and every petition will become infructuous, my lord. My lord, may kindly come to page 52, my lord. Let's say para 52, my lord. The Supreme Court has clarified, my lord, when.
Yes, I've got this.
Yes, my lord. Para 52, my lord. It says, my lord, I will read, my lord. Lordship may kindly come to para 52, my lord. Yes, my lord.
Yes.
Thus, from the above, it is crystal clear that an application for taking additional evidence on record at an appellate stage, even if filed during the pendency of the appeal, is to be heard at the time of final hearing of the appeal at a stage when, after appreciating the evidence on record, the court reaches the conclusion that additional evidence was required to be taken into record in order to pronounce judgment or for any other substantial cause. In case the applications for taking additional evidence on record has been considered and allowed prior to hearing of the appeal, the order being product of total and complete non-application of mind as to whether such evidence is required to be taken on record to pronounce the judgment or not remains inconsequential, inexecutable, and is liable to be ignored. So, my lord, now, my lord, I will just take your lordship to the order sheet, my lord. If lordship come to the order sheet at page 142, my lord, just prior to the petition filed, the previous order at page 142, my lord.
Okay.
Lordship, you will see, lordship is 28/10/2024. This is the order, my lord. And this matter was fixed for hearing, my lord, on 3/12/2024. Page 142, my lord. And thereafter, the next page, my lord. Lordship may kindly say page 143, my lord. The order of 3/12/24, my lord. Lordship will see that seen the petition of 1529/24, my lord. This is the petition requesting by the praying for, my lord, allowing him to submit some document. This petition was filed, my lord. And thereafter, lordship will see the entire order sheet I have annexed. Nowhere the matter was heard, my lord. The appeal was heard. Simply the objection was filed, and petition has been considered, my lord, by the appellate court, my lord. So that has to be considered only after final hearing of the matter, my lord.
So objection, it was fixed for objection on 18/1/2025.
Yes, we have filed our objection, my lord, thereafter, my lord.
And then?
And then, my lord, the court heard the matter and passed that impugn order, my lord, without hearing the entire appeal, because the law is settled, my lord, that only after evidence of, after going through entire evidence on record, my lord, if the court finds that this petition is required in order to pronounce judgment for adjudication, then only it should be allowed, my lord, otherwise not, my lord. Lordship may kindly see that the judgment, the next paragraph, my lord, of that judgment, my lord, para 53, my lord. What it says, my lord, in that case, in the instant case, para 53, my lord.
Okay.
In the instant case, the applications under Order 41, Rule 27 was filed on 6/4/98 and it was allowed on 28/4/1999. Though the first appeal was heard and disposed on 15/10/1999. That means subsequent date. So, in view of the law referred here and above, the order of 28/4/99 is just to be ignored.
Okay, just
So,
a moment.
Yes, madam. So now no hearing taken as place, madam.
Just a moment. Now this case is fixed for?
My lord, the case has been remanded to the trial court, my lord. My lord, the operative part, my lord, it says after taking into consideration all the above, the petition filed by the appellant is to submit treasury certificate is allowed as additional evidence. The case record is remanded back to the learned trial court with a limited purpose for taking the treasury credit certificate into a record by allowing the parties to adduce evidence on the treasury credit certificate and thereafter to transfer the additional evidence record along with the record to the appellate court for further proceeding. The learned trial court is expected to complete the entire proceeding of recording the additional evidence and sending it back to this appellate court within a period of 3 months from today. Yeah. And the matter is fixed on 1st of April, my lord.
This was fixed on which date? This
1st of
order was
April, my
passed
lord.
on-
1st April.
No, this order was passed on which date?
My lord, the order was passed on 31/26, my lord. 30 January, my lord.
Where's the order?
My lord, may I kindly come to my lord, I have held an additional affidavit, my lord.
Okay.
Page 184, my lord. It is in flag A, my lord.
Why didn't you annex the order earlier?
I have annexed, my lord, but only the last page, my lord. Last page was missing, my lord. So, my lord, I brought the complete, my lord, order again, my lord. There are 49, 50, 51, 52, my lord. Prior to that, my lord, there was stage of consideration is there, my lord.
And subsequent paragraphs are not relevant, no?
No, my lord.
This
52
is only relevant
yes, my
to,
lord. Yeah.
relating to specific relief act.
Yes, my lord.
But there's a concluding paragraph also.
Concluding paragraph, my lord.
Paragraph
Please come to the concluding paragraph, my lord. Lordship may kindly come to, my lord, that para number 85.7, my lord. Para 85 is the sum of, my lord, of the entire judgment, my lord. And 85.7 is the, my lord, our relevant part, my lord. The first appellate court committed a grave error in deciding an application under Order 41, Rule 27 much prior to the hearing of the appeal, thus the order allowing the said application is liable to be ignored as the same has been passed in gross violation of the statutory requirement. 85.7.
Document states
My lord.
only till the next date.
Yes, my lord.
Heard learned counsel, Mr.
G. Alam, my lord.
G. Alam for the petitioner, for the petitioner.
Petitioners. Defendants in the suit, my lord.
This petition under what provision?
27, my lord.
Under what provision? 227.
227, my lord.
Who has filed an application under Article 227 of the Constitution of India, challenging the impugned order dated 30/01/2026, passed in TA number 31 of 2023 by the Learned District Judge, Kamrup Metro, whereby the appellate court, without final hearing of the title appeal, allowed the petition filed by the respondent.
Yeah, my lord. Appellant, my lord.
By the appellants.
Appellant, my lord.
By the allowed the petition filed by the appellants.
By the counsel of the appellant, my lord. By the appellant himself, my lord. Counsel has filed, my lord, in his capacity.
By the learned counsel for the appellants.
Yes, my lord.
So by the order, impugned order, the appellants were allowed to adduce
Yes.
additional evidence.
Additional evidence, my lord.
As per order 41, Rule 27 of the Code of Civil Procedure, within bracket CPC for short, bracket close, full stop. It is submitted that objection was filed by the present petitioners, and the present petitioners have raised an objection. Which part of the order covers the objection?
My lord, lordship may kindly come to my lord. My lord, para 4, my lord, page 186, my lord. Page
That objection that the petition is not maintainable, as the petition was filed to fill up lacunae, LACUNAE, full stop. The appellants failed to show any reason what prevented them from obtaining the treasury credit certificate during the time of trial. The petition was not even filed, signed by the appellants, but the engaged counsel filed the petition. Full stop. The learned counsel for the petitioner has also relied on the decision of the Supreme Court in Union of India versus Ibrahim Uddin and another, reported in 2012 within brackets 8 SCC 148, wherein it has been held that paragraph 52. Paragraph 53. Paragraph 85.7. It is further submitted that that during the pendency of the appeal, the petition under Order 41 Rule 27 was allowed. Full stop. It is also contended that the order was erroneously passed, and this facilitated filling up of lacunae by the appellants. Full stop. It appears that the proceedings of the procedure of additional evidence under Order 41, Rule 27 may be stayed at least till the next date of listing. Thereby, the order allowing to adduce additional evidence under Order 41, Rule 27 is stayed till the order dated 31/2026 in TA number 31/2023 is stayed till the next date of listing. Issue notice to the respondents. Respondents are from which place?
Respondent, my lord, they are from, my lord, Gauhati only, my lord.
Okay. Dupamta list on.
9 to 4. My lord, may I pray, my lord, that further proceeding of
9 to bond over
bond over.
most probably bond over.
After view, my lord. After view, my lord. My lord, my lord. My lord, that further proceeding of TS may be also may state, my lord, along with the order, my lord. TS number 57 of 2006, pending before civil judge 2, my lord, because my lord, pursuant to the order of my lord, the my lord, that proceeding has been initiated by the civil court, trial court, my lord. So order has been stayed, not lordship has order. Subsequent.
T of how?
Yes,
T
he will not proceed.
got a
Yes. Oblige, my lord.
It is already been disposed
Yes,
of.
my lord, I will inform. They are from different. Oblige, my lord.
Item number 2.
My lord, in this case, my application to recall 2 witnesses have been rejected by the trial court. My lord, what happened? On the first day of the trial itself, 2 witnesses, PW1 and PW5, they both came to court and they had already filed their evidence on affidavit on earlier occasion. On that day, they were supposed to be cross-examined. And the counsel for the other side, who were cross-examining these 2 witnesses, when PW1 came, 2-3 questions were asked. Then he was asked that, can you read what is written in your evidence on affidavit? He said, no, I cannot read. And Your Honor, in the evidence on affidavit itself, it is very much written in a paragraph that he cannot read English or write. So the contents of the affidavit in opposition have been read over and explained to him in vernacular. And after reading the same, he has signed it. That question was not asked. He was asked, can you read English? That paper was literally given to him evidence. You read. He said, no, I cannot read. And the presiding judge, he have recorded, I do not know what is written in my evidence on affidavit. Next, my lord, it's PW 2, 3, 4 should have come, but no, that the PW 1 and 5 were present. PW 5 went. Now, next. Same, my lord, it was handed over to him. You read what you have written. He said, I don't know what is written there. I cannot read. Then again, my lord, it was recorded that I do not know what is written in my evidence on affidavit. Then, my lord, On the next time also, that day, my lord, only junior counsel was present at Bokaghat, my lord. Then subsequent date, again, evidence was fixed, PW 3-4 came. The counsel from the Gauhati, the engaged counsel went there. Same thing was used, my lord. The counsel gave it to them, you read. Witness number 3 said, I cannot read. Then the counsel objected that this is not how you should cross-examine a witness. You ask him on the content. Whereas very much it is written that he cannot read and write English. It was explained in vernacular and then he signed. Why are you asking him to read? And why is the court recording that I do not know what is written? Then court asked that counsel, no, you take your seat. We will see. Then counsel said, no, I am doing my duty. I have objection to this. This cannot be done like this. Then he was that PW 3 and 4 was cross-examined on the entire evidence and we have no problem to that. My lord, because of this conduct of the presiding judge, the petitioner, he thought that he will not get justice from this court and he lost all confidence in the court. And he was the PW1 who was cross-examined. Then we moved that petition before the district judge at Golaghat because my lord, Bokaghat comes under Golaghat, district judge is sitting there. We filed an application for transfer of the case from this magistrate to any other magistrate. Notice was issued, my lord, to the opposite party. And then we, because of this PW 1 and 2, my lord, already we had filed a recall petition. Then we have filed an application before the concerned magistrate that we already filed a transfer petition before the court at Golaghat. Kindly don't take up the matter because the petition has no confidence on this court. So don't take it. Don't hear it. Don't hear this petition. He said, no, I will not allow. And on that day, my lord, he did not allow. He fixed it for hearing. We did not take part in any hearing and all. He passed an order. He dismissed it. Now, my lord, we are saying, my lord, there are two things. One, we have filed a petition for recall of a witness. And my lord, anyways, our witness comes and says before the court, I do not know what is written. Definitely, we have to cross-examine him. On what circumstances you are saying you do not know this. And secondly, my lord, when a transfer petition was already pending, petitioner has lost confidence in the court. Now, my lord, justice should not only be done, it should seem to have been done, my lord. That is the principle. When petitioner have already filed a petition before the district justice Golaghat, this court ought to have not taken this, considered this petition, dismissed it. Now, my lord, after dismissing it, my lord, now next date is fixed for final hearing. My lord, there was an execution application. Then the petitioner, he objected to that execution application, then it went for trial. That missed case only, my lord, evidence was being laid. And now evidence is closed, next date is fixed for final hearing. So, my lord, at this stage, my lord, my prayer would be, my lord, to stay the further proceedings of that missed case, my lord. This is 07 of 24. And my lord, notice be issued.
Execution.
Execution is already stayed, my lord. That missed case is registered, my lord, because we objected to the execution. We are saying that this execution cannot be done. Then court took up that, my lord, and evidence is being laid in that case. I am praying to stay that case. Execution already stayed. May I take your lordship through the documents, my lord?
Yes.
Impugn order, my lord, is at page 76. Page 76, my lord.
Okay. 76.
76, my lord. You know? 78. Okay, so my lord, I'm sorry, my lord, 78.
78.
78, my lord.
Order dated 23/2/2026.
Yes, 23 to.
Please read the order.
My lord, both sides are represented. Today, the instant case is fixed for necessary order on petition number so and so. Now, petition number so and so was filed by the petitioner under section 142 of the BSA 2023, read with order so and so, section so and so, thereby praying for recalling of PW1 and PW5 for further cross-examination, limited to the clarification of their earlier deposition regarding their knowledge of the affidavit in Miss case number 07 of 2024. It was submitted inter alia that the cross-examination of PW1 and PW5 do not correctly reflect their actual answers and hence they were required to be recalled for getting the true picture of the case. The opposite party, on the other hand, white objection number so and so stated that the cross-examination of PW1 and PW5 was done in the open court as per law. It was also averred that the petitioner intends to render a chance to his witnesses to provide better answers to the questions. Further, it was also recited that the petitioner has filed a aforesaid petition with a malified intention and the same deserves to be rejected with cause. I had heard the both the sides at length and on the last date, that is 6/2/2026. Now, my lord, why 6/2/2020? As I said, we have not participated on the final hearing. We said we will not participate since we already filed an application. Now, it is imperative at this junction to mention that the cross-examination of PW1 and PW5 was conducted before the instant court in presence of the learned counsel appearing for the petitioner. If the petitioner or his learned engaged counsel had any objection to make regarding the recording done of the cross-examination of PW1 and PW5, such objections should have been brought before the instant court then and there, which was certainly not the case. Giving another chance to PW1 and PW5 to face their cross-examination is in a limited manner would, in my considered opinion, cause prejudice to the opposite party and is totally uncalled for in the instant case. In light of the aforesaid discussion, petition number so-and-so stands rejected and disposed of without cause. Instant miscase thus stands disposed of on contest. Now, my lord, kindly
So this, you were not allowed to cross-examine PW1 and PW5.
recall.
Recall, okay.
Now, my lord, kindly come to page 72, our application, my lord, page 72.
Only because you could not understand English, that is the question.
Yes, my lord, that I'll show, my lord. Kindly come to page number 48.
Well, let's go to page 72 first.
My lord.
Page 72.
72, my lord. Page 72, my lord. This is our application.
Mm.
Page 72.
Mm.
That today is the date fixed for the lordship is there.
Yeah.
That today is the date fixed for the case. That the applicant petitioner has preferred a transfer petition under section so and so before the Honorable District Judge Golaghat registered a mistransfer case number so and so, praying for transfer of the present miss case so and so to another competent court at Golaghat on bona fide grounds of reasonable apprehension of bias and to secure a fair hearing. That the said transfer petition has been duly filed before the Honorable District Judge Golaghat and the same is pending consideration and fixed for admission hearing to today, that is so and so. That in view of the pendency of the aforesaid transfer petition, the applicant petitioner most humbly prays that this learned court may kindly not proceed with further hearing of Mizja case number so and so until appropriate orders are passed by the Honorable District Judge in the said transfer petition. As proceeding with the case at this stage will not be proper as per judicial discipline and would defeat the very purpose of the transfer petition and cause irreparable prejudice to the applicant petitioner. To that, my lord, the order is there at page 76.
Okay.
Page 76.
Page 76 is.
76, my lord. Petitioner is represented. Opposite party is present with his learned engaged counsel. I have heard both sides as regards petition number so and so and objection so and so. Therefore, now petition number 588 was filed by the petitioner, thereby stating inter alia that the petitioner has preferred a transfer petition under section 24 so and so, which has been registered as miss case transfer so and so before the Honorable Court of District Judge Golaghat for the transfer of the instance case to another competent court at Golaghat on bona fide ground of reasonable apprehension of bias and to secure a fair hearing and view of the same. A prayer has been made to keep the instant case in abeyance until the disposal of transfer case number so and so, which is pending before the Honorable Court of District Judge Golaghat. The opposite party by the objection petition bearing number so and so contests the aforesaid petition. By this objection bearing so and so, the opposite party has submitted inter alia that the aforesaid petition has merely been filed to resist the execution proceeding with an intention to assist the judgment debtor to run the hotel business in the suit land for a longer period and that there is no order of stay by any superior court and as such the aforesaid petition is not maintainable. I have perused the case record and paid my anxious consideration to the submission made by both the sides. Upon such hearing and perusal, it appears that there is no order from any superior court to keep the instant case in abeyance or to stay the same. In my humble opinion, the instant case cannot be stayed in the absence of any order from the superior court to keep the instant case in abeyance or to stay the same. So it was rejected, my lord, and proceeded for hearing. My lord, what is very important is that on what ground we had sought for transfer of the case from this court to some other court. Kindly come to page 60. Page 60, my lord.
This is not required. Why you have sought transfer is not required.
Yes, already I have submitted, my lord. Whatever.
You were not allowed to examine your witnesses, recall your witnesses.
Yes.
You are aggrieved by that order.
Yes.
And you have come against that order.
Yes.
So that the reason why you sought transfer is not required.
My lord.
So any other?
No, my lord, I'll try to show, my lord, what is it. Kindly page 48. Page 48, my lord. My
Okay.
lord, this is how it is done, my lord.
Hmm.
My house is at Bajali district. I came to Bokaghat about 28 years ago. These two questions were put. I do not know the contents of my examination in chief. If my witness, my lord, says that this is, my lord, whatever he has submitted, my lord, it will go against me. If you are saying that you do not know the contents of examination in chief, then I have to cross-examine you whether you had signed it or not. Because anyway, he has turned hostile now. If I don't get a chance to cross-examine, and my lord, the most interesting part is that PW1 kindly come to 46.
To re-examine or cross-examine?
Re-examine, not
So you
cross.
are saying cross-examine your
No,
own witness?
re-examine, man. It will be re-examination. And my lord, page 46, he is the petitioner himself of Miss Case 07. Page number 46. For a moment, we may think that PW5, he may not know. He may be a plotted witness. But kindly see PW1, he is the petitioner himself, and he is also saying, kindly see, my lord, Sri Nipen Das is the brother of my wife. I had looked after the hotel business at the suite premises until 15 days prior to today. This also, my lord, wrongly written, my lord. I do not know the details about the original suit filed by the plaintiff or the decree passed therein. This also, my lord, we have put in there. I do not know what is written in my examination in chief on affidavit. I do not know what is written in my examination in chief on affidavit. This person is litigating. He is the person who will be affected. And when he was just given it, my lord, that you read it. All these facts we have mentioned in our transfer petition. That witnesses who do not know how to read English were given to read it. And when they say we do not know how to read, then court records that I do not know the contents. Now, my lord, these things, for repairing these things, there is only one way out. I have to re-examine, nothing else. Even if that court is transferred, I am given some other court. What is done is done.
So that procedure of re-examination in the new BNS is what?
Yes, I have given.
Under section?
I have given one. They have to pay attention to this one. Kindly take up page 49, my lord. 49. Page 49. Cross title is there of that petition.
Okay. 142.
My lord. 142. Order 813, rule 17, read with 151.
You are asking for stay of the proceedings.
Yes, 07. My trial. This trial has been, my lord.
Case number 07.
07.
Or title suit.
No, miss case 07. This
This case is concerning what?
Execution was, my lord, going on.
Hmm.
I came and filed this petition before the court that I am an interested party. I was not made a party in the main case.
Main execution case.
Yes. And
so this case is an execution case. Offshoot of an execution case.
Yes, my lord. And that execution case already stayed, my lord. Now the stay of the
Do
case.
you have the order, stay order of the execution case?
It is stayed, my lord, because this case is going on. I am not asking for stay of that also, my lord. This, my lord, 07, my lord. This is my case, my lord. That is launched by me. I am asking stay of that because next date is fixed for final hearing.
Heard learned counsel, Mr.
F. Khan. Firoz
F.
Khan.
Khan, for the petitioner, Sri Topan Gogol, who is the petitioner of the midday case number? Also the
07 of 2024.
petitioner of the midday case number 07 of 2024. Full stop. The petitioner, while adducing evidence, the petitioner has prayed, the petitioner has prayed to recall witnesses for re-examination as certain questions were asked to the petitioner to his prejudice. Full stop. The learned trial court, however, rejected the prayer of the petitioner to recall witnesses as per section 142 of the BNSS.
Yeah, BSA,
BSA, 142 of the BSA,
read with order
read with order
18,
order 18, rule 17.
rule 17, read with 151 of the CPC.
Order 18, rule 17, read with section 151 of the CPC.
Yes.
Full stop. It is submitted that the observation of the learned trial code that the petitioner is trying to fill up lacunae
Yes.
is not correct. Full stop. The petitioner has been highly prejudiced as the petitioner the highly prejudiced due to certain questions asked during his cross-examination. Okay. All right.
Yes. No, my lord, I'm sorry, my lord.
Certain questions asked during his cross-examination.
During his and his witness, one of his
During the cross-examination of the petitioner and
one of his
one of his witnesses. Full stop. In any case, a court may allow a court may allow a party to recall witnesses to unearth the truth.
Yes.
Considering the submissions, it appears that further proceeding of Midge case number 7 of 2026,
24.
2024 may be stayed, at least till the next date of listing. Issue notice to the respondents. Meanwhile, further proceeding of Midge case number 7 of 2024 is stayed till date to dismissal.
22nd.
My lord.
Will not need records, I think.
Not
Records are
required.
not
I have annexed everything.
Item 3.
I'm grateful, my lord.
Okay.
Item number 3.
Parties are not represented, list this matter after 2 weeks.
Item number 4.
Parties are not represented, no, petitioner is not represented.
Your Lordship, I am the petitioner appearing in person. This petition is limited only to seeking expeditious disposal of two civil suits pending for 10 and 11 years before the civil judge Hojai. One suit is already at final argument and the other is at defendant evidence, yet both are not progressing and are repeatedly adjourned. The delay is causing serious prejudice as it concerns my only family property and livelihood. I am not seeking any relief on merit, only a direction for time-bound disposal. I humbly pray this honorable court may kindly issue appropriate directions. Your Lordship, the courts have held that justice delay is justice denied, and it is violating my right to life under Article 21. Opposite party is taking frequent adjournment, causing intentional delay. And for this lot of financial loss I'm suffering, and that using this particular time for causing unnecessary harassment to me.
This case is pending at which stage?
Your Lordship, TS 5015 reach final argument stage, whereas 2316 is a defendant witness.
Two cases.
Two cases are there. Your Lordship, total time it became 10 to 11 years. But unnecessary adjournments are happening.
Okay, I can give a direction. I'll pass an order today.
Thank you.
You are present alone. You are the petitioner in person.
Yes.
What about the others?
Pardon?
What about the others? Manju Singh, Jyoti Singh, Niva Singh?
She is my mother,
Okay.
and whereas Nibha Singh and Jyoti Singh is my sister.
Okay.
So they,
Wait for a while I pass the orders. You can sit down. You can assist me. Petitioner Santosh Singh is present in person. He has filed his application under section 115 of the under Article Litigant. Under Article 227 of the Constitution of India, read with section 115 of the Code of Civil Procedure within bracket 1908 bracket close. You see, this is not section 227. So can you correct it? You should write Article 227. Okay. Article 227 of the Constitution of India. How will you get it corrected?
pardon, ma'am?
How will you get it corrected? You file an application
Yeah, I will file an application.
tomorrow, day after tomorrow?
Yeah.
Okay. To get the, it should be article. The petitioner in person has submitted that he will file an application to get the to get or to correct the error apparent on page 1 of the application. Okay. List this matter on within 2-3 days. You file an application and correct it.
Okay.
List this matter on the date the date, sir.
26th of March.
26th of March. 26th.
Your Lordship, basically, I filed this application earlier under Article 227, but it was rejected by registry. They told me that to file it under CRPIO. So as per the instruction only, I have
No,
filed
you see, you have mentioned
your section.
so it's better you get it corrected
Okay.
on 26. That's page 1.
Page
You
120.
see the order, then you'll get to know where you have erred. Okay.
Item 5.
May I apologize, Lordship, 2 weeks time may be granted.
I am for responding, my lord.
2 weeks time.
It's my lord, date, my lord,
Okay.
date may kindly be fixed, my lord. on-
Your name, Learned Counsel, Mr.
Mr.
Why Ali? On behalf of A Ali.
is present on behalf of Learned Counsel, Mr. A. Ali, and has prayed for time. Learned Counsel, Mr.
S. Ahmed,
S. Ahmed
For-
is
for
present for
respondents.
respondent number 1 and 2. List this matter dated the due. 7th April.
my lord, 20 April is my lord better, my lord.
20
7
April.
April, my lord,
After
after
verification.
All right, 20 April.
20
Yes.
April, my lord.
Hi,
Much
Lordship.
obliged, lordships.
Item 6.
Lordship, let me pass over for the day.
Pass over for the day. A request has been made by the by Mr.
Be there, Lordship.
B. Davy to pass over the matter for the day.
You.
Item number 7.
Paying for some accommodation, my lords. Mr. P.K. Rai Chaudhary has been newly appointed in this matter. He needs some time. Your lordship, can it be on 21st of April, your lordship?
Sure. Learned Counsel, Mr.
R. Ghosh on behalf of P.K. Rai.
Our host is present on behalf of Learned Counsel, Mr. P.K. Roy Chaudhary, and has paid for time to place and has prayed for time to place a submission. Learned Counsel, Mr.
J. Das
J. Das is present
for the respondents.
for the respondents. List this matter. When do you want?
21st of April, 20 or 21st of April.
21st? Okay.
Deeply obliged. Deeply obliged.
Item 8.
It is your lordship. Lordship, may kindly pass over the matter for the day, lordship.
A request has been made by learned counsel, Mr.
Assing lordship.
A assessing or
Assessing lordship.
assessing to pass over the matter for the day, full stop, learned counsel, Mr.
As shown on behalf of Mr. S. Datta.
As shown is present on behalf of learned counsel, senior counsel. Mr.
Senior
S.
counsel,
Datta.
Mr. S. Datta.
Whatever date
List
may be.
after, date, you want a date?
Date.
List on
22nd.
22nd April.
Obliged lordship.
Obliged.
Item 9 for authorization.
Wait, please, lordship. So here in this case, response number 2 expired, lordship. Earlier we took time, in fact, lordship, we could not collect the legal years of response number
Response
2.
number 2. Okay.
They are from Rajasthan.
Mhm.
So we need some more time.
Okay. All right. Learned counsel, Mr. M. Talukdar
Lordship.
has prayed for time to obtain the
Details of legal years.
details of legal heirs of respondent number
2.
2 who has passed away. Okay? This the
And
matter after,
moreover, the correct address of response number 3.
and also to obtain the correct address of respondent number 3.
Lordship.
This the matter after
After
2,
B vacation.
after BU vacation.
Lordship.
Okay.
Obliged.
Item 10.
Wait, please, Lordship. Lordship, we have taken steps upon respondent number 2. However, the same is not reflected in the office note. We have taken steps on 19th of March.
Okay. Learned counsel, Mr.
H. Buragman.
H. Buragman is present for the appellants and has submitted that the office note does not reflect that they have taken steps on respondent number 2. Full stop. It is submitted that steps have been taken on respondent number 2 on
19th of March.
19 March 2026. Learned counsel, Mr.
BB Gauhati for respondent 1.
BP Kakoti is present for respondent number 1. We have only 2 respondents here.
Two respondents.
Okay, list after 2 weeks.
Obliged. Obliged.
Item 11.
May it please your lordship, service has been completed for respondent number 2, and in the meantime, we have filed our amended cost title as per last court's order.
Your Lordship, I have filed the Wakalatnama on behalf of respondent number 1A to 1C.
1A and 2,
1C.
1C, okay. Learned counsel, Miss
S. Sharma.
S. Sharma is present and has submitted that they have filed
Amended cost title.
an amended cost title, and they have also taken
Taken
steps.
Dusty also for respondent number 2, but they have
Taken-
not appeared till date.
The notices have been served.
Answered notice has returned for respondent number 2.
And they have taken steps to issue notice to respondent number 2. Full stop, office note dated
27 to
27/2, no? Latest office note we do not have. We have the latest office note, no,
19.
so service report is awaited. Service report on respondent number 2 is awaited, 1 and 2.
2.
2 is awaited, learned counsel, Miss
M. Bhattacharjee
M.
on
Bhattacharjee is present for respondent number 1,
1A to 1C except 2
1A to 1C,
and 3 to 8.
1 small a,
Small a.
Legal heirs
up
of
2 TO2, 1 small c. And
1
respondents
A,
number
B, C. 1A, 1B, 1C.
C লিখিলে ভালো হবে। And respondents number 3
3 to 8.
3 TO2 8. And
lordship,
full
and
stop video.
in the meantime, lordship, call for the trial court records.
Okay.
as well.
Call for the trial court records. We did not call earlier.
No, your lordship.
Dispose of cases.
IA has been disposed on the last occasion, but
We call for a scan copies there.
yes, your lordship.
Pending case, no?
Yes, your lordship.
Call for a scan copies of the trial court records. You'll need them?
Yes, lordship.
Okay.
Fix the date. I will
All
fix
right.
the date.
Okay. List after how many weeks? 2, 3?
Lordship, 3 weeks.
List after 3 weeks.
Item number 12.
May I please?
Lordship, this section 24 application
Oh,
for transfer of FC case number 532 of 2003 under section 13(1) of the Hindu Marriage Act pending in the court of Learned Principal Judge of Family Court 3, Kamrup Metro, Gauhati, to the court of Learned District Judge Sonitpur at Tejpur. Lordship, I am for the husband, Lordship.
notice has been served.
Lordship, copy has been served.
Objection to
respondent
be
should-
filed by counsel has not been received by the section. Okay. 19/3/26. Objection had not been
They are
submitted.
supposed to file objection, but
Mm.
till date it has not been filed.
So your next day, if they don't file, then we will proceed.
Lordship, let the interim order be continued till date.
Interim order.
Lordship.
Is there any interim order?
Yes, Lordship, interim order
Okay.
was there.
Learned counsel, Miss
Devasri Chakraborty.
D. Chakraborty is present on behalf of the petitioner. Full stop, the respondents did not file objection, full stop. The respondents are directed to file for objection positively on the next date fixed, failing which necessary orders may be passed, full stop. Interim order shall remain in force till the next date of listing, list after 2 weeks.
Item 13. Item 13.
None appears on call, list after 2 weeks. On failure of appearance of any of the parties, adverse orders may follow on the next date of listing.
Item 14.
Parties are not represented, list after 2 weeks. On failure of appearance of any of the parties on the next date of listing, adverse orders may follow.
Item 15.
Parties are not represented.
Absolutely. Item 15, Lord.
Hmm,
So as per office note dated 19/3/2026, Lord.
hmm,
Answer notice upon the all the respondent, Lordship.
hmm.
Sometime may be granted, Lordship, taking fresh steps.
You want to take first step. Learned counsel, Mr.
Be ready.
B. Devi is present for the petitioners. Full stop. Office note dated indicates that dated 19/3/2023/26 indicates that survey report on respondents number 1, 2, 3, 4, and 5 is awaited. Full stop. The petitioners may take fresh steps to issue notice to the respondents. List after 4 weeks.
Lordship, I'm sorry, Lordship, item 6, there is an interim, Lordship.
Item 6.
Lordship.
কোন আছিল item 6? এই কৈ দিবচোন দেই, interim order to continue কৰিবলৈ নিবেদিতা।
Hey, boss.
Item 16.
Your ladyship, the service in this matter is complete. So the matter may kindly be fixed for admission.
Admission, okay. Learned counsel, Miss
J. Handik.
J. Hendik is present for the petitioners. Petitioner, no?
Yes,
Petitioners.
yes, Your Lordship.
Learned counsel, Mr. P. Goswami.
R. Gusam.
R. Goswami is present for respondent number
Respondent 3.
3. Full stop. Office note dated 4/6/2020. Oh no. Where is the office note of service report? Office note dated 4/6/2025 indicates that Wakalandamas have also been filed for respondent number 1 and 2. How many respondents we have? in this
Respondents?
case? 3?
3.
Sure.
I'm for the
Three, okay,
particular.
we have three respondents. List this matter in the admission column. List this matter in the admission column. Should I give you some time?
Lordship, yes, Lordship. I'm making mention that typographical error in that order, Lordship.
Okay, okay.
If it can be listed tomorrow, day after anyway.
Mention.
Lordship, there's an order on 6 to 26.
It will
That needs to be corrected.
You'll have to mention before the regular bench. Regular first appeal bench, middle
This
court
order,
bench.
this is an order related to pass by your Lordship. That is correction.
You'll have to mention before middle court.
It has to come to this court only.
It will come, but you'll have to mention before middle court. Middle court আছে no regular?
Lordship.
Obliged. Admission, should I give you date or you want a fixed date or you want a?
It can be
A
disputed.
date may currently be fixed.
Huh?
Any date may currently be fixed.
This is the matter on date. 28th.
This is a covered matter. Batch of such CFPs and appeals were disposed of by this honorable court
Okay,
on 26th of February.
this matter.
This matter. This also similar number of matters, about 20 cases were disposed of.
Disposed of. We have any pending? Any pending? So we can bring it up together.
No, I have only this case, but if there might be one or two left out,
Okay.
but a batch of cases were
So
disposed of.
date the DDA. 20 April will be fine.
Obliged.
Item 17.
Parties are not represented today. List this matter after 2 weeks positively without fail. First, the parties are directed to appear after 2 weeks positively without fail. এটা last দিলে হ'ব positively দুবাৰ দুবাৰ নালাগে.
Item number 18 and 19.
May I please,
Hmm.
in item 18,
Hmm.
there is a IA 4050/25. Here, my appellant express. So we have filed a substitution petition, which is 4050, 4051.
IA 4050.
Is a delay of 21 days in filing the substitution petition. Actually, they have no objection because there's 21 days delay. So
IA 4050.
4050/25
Learned counsel, Mr.
and hoc.
N. Hawk is present for the applicant who has filed this application. Under section 5 of the Limitation Act, we pray for continuation of how many days? Delay?
21 days.
Delay of 21 days in filing the what?
Application for substitution
Application for substitution of legal heirs
of the, my lord, appellant.
of the appellant. Learned counsel, Mr. B.K. Sharma. B.K. Sharma.
I have something to say.
Appellant.
That is
Is present for, you are present for?
Rest-
Response.
respond.
For the respondents. What do you want to say?
Now, my lord, in this case, the appellant filed one application seeking the substitution of the respondent. This is respondent number 4. But that petition was not allowed.
What happened, my lord? Respondent number 1, he expired. Then we file a substitution petition.
Hmm.
During pendency of that substitution petitions, the appellant expires. So first appellant must be substituted first, then my lord respondent. Otherwise, that is safe.
So you have any objection? 21 days delay?
I think I have got no objection, but one thing, my lord, that the petition is not supported by any death certificate or next to kin of the deceased. So these things were not done. This is
In
the,
this condemnation or delay application, do you have any
yes, I
objection?
have got no objection about this. But thing is this, that they have not mentioned the place of date of the deceased.
That one will take up some other day.
Pardon?
Substitution petition will take up some other day. Today here you have no objection, I allow this petition application. Has raised no objection, full stop. It is submitted that the delay was not intentional, full stop. I have considered the submissions at the bar, full stop. No malafide is discernible on the part of the petitioner. thereby delay is condoned. Delay of 21 days is condoned to file an application for substitution of legal heirs of the deceased appellant Kamala Das, alias Kamala Prabha Das.
Right.
In terms of the above observation, this application stands disposed of.
My already substitution petition is there, already on record.
Mm.
4051.
4051.
51.
4051 খন দিয়াচোন।
দাদা
22
4051.
4051 petition খন দিয়াচোন।
Page 6, my lord, paragraph 2. 3 daughters, my lord.
Actually, all that's not that. You have mentioned in your petition, the petitioner number 2 is its own. But unfortunately, you have mentioned all our letters.
2 as
2 is found. And
Two is-
while 1 and 3 are
Is not
daughter.
that. Page 6, my lord, paragraph 2. They are the legal heirs of my appellant.
But my submission is your lordship, that his petition ought to have been supported by a next to kin certificate issued by the deputy commissioner as to the legal heirs name. But he has not done it.
Others, my lord, petitioners may not have interest in this appeal, my lord. They have interest, they want to be substituted.
Not substitute.
And there is no, my lord, any doubt that they are the daughters of the appellant or sons of the appellants or not.
All the legal heirs or
All the not, sir. All the not, three legal heirs. And others are not interested to contest. These 3 persons, that is 2, 1, 2, 2, and 2, 3. They are,
you are the appellant.
I'm the appellant.
Heard learned counsel Mr. S. Hawk, no?
And how?
N. Hawk for the applicant who has submitted that the appellant Kamala Das alias Kamala Prabha Das has passed away, leaving behind legal representatives, full stop. The legal heirs as follows are interested to pursue the appeal registered as RSA number 301 of 2014. Whereas the other legal heirs are not interested, and thereby the legal heirs, namely Malabika Pathak, Sushil Kumar Das, and Ornima Soikia may be impleaded as may be substituted in place of the deceased appellant, deceased appellant Kamala Das alias Kamala Prabha Das. Full stop. The learned counsel for the respondents, Mr. B. Sharma, has submitted that the petition is not supported by a legal heir certificate, and all the legal heirs are to be impleaded and substituted. Full stop. I have considered the submissions at the bar with circumspection. Full stop. I have considered the submission that the legal heirs Malavika Pathak, Sushil Kumar Das, and Ornima Soikia are interested to pursue the appeal, and thereby prayer and thereby petition is allowed to substitute the aforementioned legal heirs in place of the deceased appellant Kamala Das alias Kamala Prabha Das. In terms of the above observation, this application stands disposed of.
Another IF 4052 of 25, that is when setting aside for abatement. 4052. Since both the petition is allowed, my lord, abatement may be, my lord.
Heard Mr. as N. Hawk. Nam duta likhi diba ha. The who has filed this application under Order 22 Rule 9 of the CPC for setting aside the abatement, ABATE, abatement of the appeal on death of appellant Kamala Das alias Kamala Prabha Das. I have considered the submissions at the bar. The abatement is hereby set aside. In terms of the above observation, this application stands disposed of. Anything else?
Now, Mala, we have to correct the Mala cost title of the AP.
Okay. Disposed of and the appellant may file the amended cost title
My problems.
in the connected appeal. In the connected second appeal.
Second.
So the second appeal to Liquidia, both the parties are represented. List this matter. Hey, do it Liquidia. List
No,
this.
in 19, my lord.
18.
In 19.
List this matter after 2 weeks. 2 weeks? After 2 weeks?
My.
Okay.
After Bihu.
After Bihu. List this matter after 4 weeks then? Or you want a date? Do you want a date? No. 4 weeks after. List this matter after 4 weeks, okay.
Only son.
19.
19.
What do you want in 19?
Same for the appellant.
Against the same judgment, a two appeal was filed.
Okay. So
If-
what
if
do you
the-
want in appeal? The other one? Appeal number 19? Oh, item number 19? You fix the date. Parties are represented?
Is for the appellant.
Yeah. And what about respondent there?
I am.
Same
40.
respondent,
Same
so it may come up after 4 weeks along with.
Okay.
Well,
Into একে লিখি দিবা 19 to একে লিখি দিবা।
After.
If you lordship,
Mr. What is your name?
D Hazarika.
C. Hazarika is present for the appeal. Our respondent নাম একে লিখি
make
দিবা।
it within. My lord, I have got also difficulties. So if your lordship can possibly in the month of May.
First week of May, no problem.
Yes. First week of May. Data detail.
First week of.
In the month of May, first week of May.
First week of May, sir.
First week of May, data detail. 5th May. 7. Data 7 May di diba? 7 May.
Yeah.
So
নালাগে এটা থাকবে। Oh, data দিব লাগিব।
After Bihu vacation, any date.
Adjournment দিয়া বুলি কৈ পেলাই ডেট এটা দি দিব কবা। পাছ অভাৰটো আঁতৰাই পেলাই পাছ অভাৰটো আঁতৰাই এডজৰ্ণমেণ্টৰ কাৰণে দিয়া বুলি কয়।
23rd of December. First week of May, any day.
এডজৰ্ণমেণ্ট আঁতৰাই দিব কবা। এটা পাছ অভাৰটো আঁতৰাই দিব কবা। আৰু আছে নেকি? আইটেম নাম্বাৰ
May I please your lordship? Lordship, this application is under section 5 of the Limitation Act, praying for condemnation of delay of 19 days, your lordship.
Whatever it is, you'll have to issue notice.
Lordship.
Because this is a private respondent.
Yes,
Learned Counsel, Mr.
N. Hazarika.
N. Hazarika is present on behalf of Learned Counsel on behalf of whom?
Nazrul Haq Mazhar, N.H. Mazhar.
NS Mazhar Bhuya, full stop. Applicant to take steps to issue notice to the respondents, returnable within 4 weeks. List accordingly. Article 21.
Your Lordship, we have filed the IA under section 5 of the limitation.
You'll have to issue notice. What is your name?
PR Chaudhary on behalf of H. Gupta.
Learned Counsel Ms. PR Chaudhary on behalf of Learned Counsel Mr. H. Gupta is present. Full stop. Applicant to take steps to issue notice to respondents. List after 4 weeks.
Obliged.
আৰু আছে নেকি? মই আজি সেই নহ'ব বুলি ভাবিছিলো। 4:30 বাজি গ'ল কিন্তু।